voluntarily turn themselves in
So
within the period of 15 days granted by
they can just
President.
report to the nearest military detachment, police precinct, police station.
That is right, and that police station or military unit, whatever it may be, will just have to coordinate directly with the Bureau of Corrections.
Thank you for the clarification. Meron pa? Kay Chief Superintendent Marquez, after you signed the memorandum to release PDL's, the three, Balansag, Canyo, and Asnar, were they subsequently issued corrections order similar to what Chief Superintendent Faustino issued? Kasi sa Davao Penal Colony, and I think he's here, di ba? Can you come forward, please? Because I'll ask you a similar question. Were they subsequently issued corrections order?
Sir, may I answer first may I reiterate first my first answer that my office is not a normal route for releases.
No, I'm
and that's
only
why
asking.
I am not totally aware, sir. The person, I think it was Corrections Officer Abad, who was hand carrying the documents, took all the documents and left. And after that, I am not totally aware, sir, what happened.
Who is Corrections Officer Abad?
He's an officer, I think, of the DSR or office of the director. I'm not so sure, but
So he's
any
in
of the-
charge?
He's a colleague from the Bureau of Corrections, Your Honor.
Hindi siya pareho ng posisyon ni Chief Superintendent.
No, Your Honor.
So why siya yung nag-hand carry noong
Yes, Your Honor.
to be signed
Yes.
memorandum?
Because it was late afternoon, Your Honor.
Yeah. So ang tanong ko is, were they subsequently issued corrections order similar to what Chief Superintendent Faustino issued?
Your Honor, I have no direct knowledge on that
Taga
question.
Muntinlupa kayo, sinong tatanungin namin? Kayo yung,
Sir, it
kayo
will-
pa man yung, excuse me, kayo pa man yung na-designate as one of those authorized to sign for the Director General, and yet you don't even know the procedure.
Sir, once the documents are signed, it will revert to the office of the director and then back to the documents.
No,
division.
I'm asking procedure here. Hindi mo kabisado na after you sign the memorandum for the Director General, the corresponding superintendent noong National Bilibid
Yes,
Prisons
sir.
or yung facility should issue a corrections order?
Yes, sir. And
Yun ang tinatanong
yes,
ko.
Sir. Correct, sir.
So ang tanong ko,
Discharge
where
order.
they issued Asnar, Canyo, and Balansag, where they issued correspondingly corrections order?
I'm not totally aware, sir, because that was roughly 6:30 in the evening. So I had to.
Gabi pa. Ba't inaapuro kayo hanggang gabi? Ano ba
The
yan?
documents were taken to me roughly around 5.
After office hours?
Around 5, sir, and I
So-
had
so-
to review.
Sobrang special. Anyway, Chief Superintendent Pastino, this is a corrections order that you signed.
Yes, sir. Pertaining to...
Did you bring with you the memorandum to release PDL Chen Chang Itis?
I have a copy, sir.
You have a copy? Can you submit to the
May I?
committee? Sige, please. So that's the procedure. A memorandum to release PDL is signed by the Director General or his authorized and designated representative, and then a corrections order will be issued by the superintendent. Ayun ang tinatanong ko kanina. Now, you just revealed na after 5 o'clock, dinala sa bahay or sa office?
I think roughly 4:30.
Oh, na ngayon
they
pa,
asked me
4:30
to
na.
stay behind.
Alam nyo, the more you talk, the more we suspect.
Sir, I can vouch.
What's
that-
so special about the 44 PDLs that you have to stay behind and sign the documents on that particular day? That's my question.
Sir,
Could it
as-
not wait the following day or 2 days after?
Sir,
Ang sagot mo, baka ma-arbitrary detention.
Yes, Your
Which
Honor.
I already countered na walang arbitrary detention. Because yung arbitrary detention is applicable to citizens arrest, warrantless arrest. Yung arrest without warrant. Eh, sasabihin mo, kakatwiran mo, idea ba yan o legal opinion ba yan ni Attorney Santos?
Sir,
Where's Attorney Santos? Ba't nawala? Yung ba yung legal opinion ng legal officer ng Bucor na kailangan pirmahan pag sinabing August 16, kailangan pirmahan ng August 16 kasi ma-arbitrary detention?
I understand, sir, that the release document should be acted promptly and that we may be charged for such violations, sir.
Who said that?
There was a communication that the document
Can you
should be
furnish the
processed.
committee that communication? That's an official communication coming from whom?
I'll see, Your Honor.
Yeah, if it came from a illegal officer, he should be disbarred. Kasi hindi niya alam yung batas.
Lawyer ba nabigay sa'yo? Lawyer? Ma'am?
Sir, I got the copy from the Assistant Chief document, sir.
Namatay na yan, di ba?
No,
Diba? Si Troya?
No,
Assistant
sir.
Chief Documents Officer yan.
No, sir. It's Mr. Roque, sir.
Mr. Roque.
You know, Ms. Marquez, we're not here to beat a dead horse. Ano? Si Nick, in fairness to him, he already left the facilities, di ba, last night or early this morning. And we hate doing this, but you know, these are procedures that we have to be clarified with.
Yes, Your Honor.
Now, sino yung nagsabi na kailangan ma-release on o mapirmahan noong August 16 dahil ma-arbitrary detention? Can you furnish the committee that document, that communication?
Sige, look for it and we will get back because I'd like to proceed to our Secretary because he might leave us. It's the 11th hour and also Senator Secretary Mendoza, with your permission.
Oh, the legal officer is here. I want to hear his
Oh.
legal opinion. Did you render that legal opinion sa Bureau na pagka hindi napirmahan on a particular date, the person or persons concerned may be charged with arbitrary detention?
Yes, sir.
Okay. Kindly explain. Kindly expound. Kindly educate us.
Article 114. Sorry.
124.
124.
Oh,
Any
124.
public officer or employee who, without legal grounds, sir, and most of the court decision ordered us to release the prisoner unless there are other legal grounds to hold them. And if the court orders that they should be released and they have no pending case, and or if they have pending case, we turn over them to the court, to the respective court, and if not, we release them. We made a memorandum of release.
In the case of Astar, Canyo, and Balansag, meron bang court order to release them?
No, sir. There was this
Sinight mo kasi pagka may court order to release, kailangan release ka agad eh.
Sir,
Meron bang court order to release them?
no, sir. There was a demand from their lawyer.
Oh,
Uh,
is that legally binding if there's a demand from the lawyer? I'm not a lawyer pero mukhang mali yun ah.
No, sir. What happened was there was this letter from their lawyer that was brought to the office of the director, and there was this action slip referring that to me to make appropriate action or compliance. And I've sent that letter to the document section to facilitate if they are qualified, because I don't know if they are qualified. So the document section check on that, and that's where my part ends.
And it could not wait. Hindi makahintay ito ng kinabukasan. Kasi baka ma-arbitrary detention based on Article 124 of the Revised Penal Code. Yun ba yun?
No, sir. No, sir.
Oh, yun na sinabi mo kanina.
I only facilitated the
No, but ang premise natin, kailangan i-release ka agad, kailangan pirmahan ka agad yung memorandum kasi baka ma-charge ng arbitrary detention. And you're citing Article 124. Ang sinabi mo pa, kung merong court order, kailangan i-release ka agad. Ang tanong ko, meron bang release order ng court? Ang sabi mo, teka muna,
Yes, sir.
sabi mo, wala. So anong basis ba't kailangan madaliin?
Sir, the basis is the decision, the recent decision of the Supreme Court requiring us to recompute, not to release, sir. To recompute.
O iba na naman siya sabi mo, recompute,
Yes, sir.
but not to release. Yung release can wait,
Yes, sir.
another 24 hours, even 1 week. And you will not be charged. Tama?
Sir, may I continue, sir?
Hindi, pero ma-charge ka ba kung na-delay ng 2 days?
No,
Dahil wala yung director, general? Kasi yun ang reason eh. Kailan pirmahan kagad ni Chief Superintendent Marquez kasi yung Director General nasa sablayan. At kung hindi mapirmahan kagad, ang sabi niya, baka ma-charge ng arbitrary detention. So I referred to you, being the legal officer, ikaw ba yung nagbigay ng legal opinion na pwedeng ma-charge ng arbitrary detention? Ang sabi mo, yes. At sinite mo, Article 124, ang sinabi mo, pag may court order, kailangan i-release. Ang tanong ko, meron bang court order? Wala. So ang tanong ko ulit pabalik, bakit kailangan madaliin at kailangan August 16? May commitment ba to release, to sign the memorandum on August 16? Commitment ba yon?
No, sir, I'm not particular.
No. Inililigaw, nagpaikot-ikot tayo eh. Simple lang yung flow ng communication natin or discussion natin this morning. Di ba? Bakit kailangan pirmahan ng August 16?
I did not told them to sign it on the same day. I only referring to this and thereafter to cause their immediate release from prison in case of full service of sentence, unless they are being confined thereat for any other lawful cause.
Pero yung Chief Superintendent Marquez, nag-relay nga sa legal opinion mo na baka ma-charge daw sila ng arbitrary detention.
No, sir, I did not give my legal opinion to them. I gave my legal opinion to all of those are similarly situated like that. Previously kasi, sir.
So, simplify na lang natin kasi paikot-ikot. So, walang masama kung hinintay si Director General Pael doon na bumalik at mapirmahan yung memorandum order. So,
Yes, sir.
si Chief Superintendent Marquez need not sign on that particular day. Kasi tapos na yung office hours eh.
Yes, sir.
Sabi niya, 5 o'clock. So, in-adjust pa ng 4:30. Pero bago mo mapirmahan lahat yung 44, inabot ka na rin ng 6:30. Hindi po ba? Oh. Ano yung urgency? That's my question. You try to disabuse our minds. Ano yung urgency? And justify it.
Sir, I understand it is under their prison manual.
Naku,
to act.
Mariosep. Balik na naman tayo sa prison manual. Never mind. No?
Yes, sir.
We can draw conclusions from there. Thank you.
Sir, may I say something, sir? Sir,
Go ahead.
I would like to correct the minds of everyone, sir, that we at the Bureau of Corrections are performing our duties well. And it is, I think if the committee finds the one or two or whoever guilty, and then that will be the time that we think of other persons, sir, because generally speaking, sir, I've been in the Bureau for more than 34 years and I've worked with a lot of hardworking people, sir. I'm
Well, we
doing a very good
never
justice,
accuse.
sir.
We are.
Yes, sir.
The system is the one that is being investigated,
Yes, sir.
not personalities.
Thank you, sir.
And if you've worked for the last 34 years, you would know, and you had not answered the question, na yung litrato ni Sanchez dito na naka-uniforme siya ng iba, dapat masasagot mo sa akin. Hindi mo na nga sinagot eh. And I'll tell you something else. Maybe there are many good people working
Yes,
there.
sir.
But I'll tell you something. Isang pinalabas yung Chinese, hindi na panahon ni Director General Paldo para hindi nyo sasabihin na pinag-iinitan namin siya. Nahuli na siya ng cellphone and device, and he is one of those who were asked to be out, to go out. No, he took advantage of this GCTA. Meron nahuli ng Chinese drugs rin. May night. I'll give you the name. Ito si Paul Chen, Tis Chang. I cannot believe you do not know that this is happening. Kaya sinabi ko, are you blind? Not out of pique, but because any kid who goes in there will know hindi balansyado. We are trying to fix the system. So don't try to be a hero at the expense of the judicial system. You can defend all your people there as much as you want. Pero all the records show na hindi happy ang tao sa patakbo sa Bureau of Prisons. Especially if you, a high-ranking officer, cannot even tell me na hindi mo alam na nangyayari ng mga cellphone, yung mga knives, yung mga everything. So do not lecture us on that.
No, sir, I'm just
No,
trying.
that's enough.
I'm sorry, sir.
You wait, because we're going to get some one here. Now, I know I want to make sure that Secretary Ibarra and Secretary Mendoza have to say here. I just have one final question para matapos na. I just have to get it off my chest. Do you have any, are you aware of any arrangements with other agencies of the government where you can put prisoners in them, other than that what is prescribed by law? Secretary Ibarra muna. Are you aware of any arrangement where prisoners, like Chinese drug pushers, are you aware that they are being placed in other prisons or other systems that are not authorized by law?
Not authorized by law, definitely no.
Sir, which is the principal office that is authorized to keep prisoners that have been convicted? Is it not the Bureau of Prisons, believe it, and the other six, like Iwai, like Sablayan, like Leyte, and everything? Is that correct, sir?
That is correct, Mr. Chair.
No, sir.
All the regional prisons as well as the National Believed Prison under the direct control of the Bureau of Corrections.
That's correct, sir. Now, this morning, sir, I got a text from media, and they told me that several people are Chinese personalities, high personalities are in the Philippine Marine Compound in Fort Bonifacio by virtue of a MOA confirmed by Bucor. Did that pass through your officer?
I remember that there was an agreement for certain PDLs for security reasons to be moved to the prisons, not the prisons, but the Marines facilities for some very special security reasons.
Well, that's why I asked you preliminarily. I laid the predicate if you're aware, and that we all know as lawyers that Bureau of Prisons lang talagang pwedeng humawak niyan, and that the Secretary of Justice must be made aware of the fact if there are prisoners being transferred to a compound, like in the case of that American guy who was convicted of killing Soji, transgender, alam natin yun, di ba? By international agreement, right? But ito, Peter Ko, Vicente Z, Hans Tan, Jose Chua, Froilan Prestize, Jojo Baligod, Alan Sinugat, Nonito Arile, Joel Capones, Rico Caja. They're confined at the Philippine Marines Compound in Fort Bonifacio by virtue of a MOA confirmed by Bucor. Are you aware of that, sir?
I am aware, but I have not seen that memorandum of agreement, Mr. Chair.
And if you saw that, would you allow it? I'm sure you would allow it for good reason.
For good reasons, definitely. My understanding is that there
And
was...
with permission of the court.
I'm sorry, sir. With, it really depends on the specific reasons or justification for the arrangement to be made. As far as I remember, that particular arrangement was done for security reasons because I think these people are witnesses to a certain case.
I agree with you, sir. But again, part of the witness protection program, but it goes through that. But as far as I know, you cannot do it without permission of the court. Would that be correct, sir?
Without permission of the court, meaning the transfer of this...
Yes, sir.
Yes, I think that is a requirement to obtain the
Would you
permission of the court.
would you favor us, sir, by checking on this? I'll give you the names para masiguro natin. Again, this is not to blame anybody. This is to fix the problem. Because nobody should be allowed to casually go into a memorandum of agreement and transfer prisoners, especially who may be high value or high prisoners that have are involved in dangerous drugs or whatever, to be transferred. Thank you, sir. Now we would like to ask, this is the technical aspect, and before I do that, I'd like to let you know that the Honorable Ramon Bong Revilla Jr. is here, also present in this investigation. Sir, as you are aware, there are certain constitutional issues that may be involved when we change the law, when we amend the law. Would that be correct? I know that's general, but we can be specific.
Yes, sir.
Yes, sir. In fact, particularly in the matter of possibility of ex post facto legislation.
Yes, Mr. Chair.
So if we amend the law right now, because there is an obvious lack of clarity or lack of decisiveness or resoluteness is perhaps a better word, on whether you include or exclude certain prisoners from the privileges of GCTA, and if they're heinous, to be very precise, if they're heinous criminals, they should not be given that privilege. So we agree, and we have talked about this previously, that it must be procedural in nature ang ating papalitan. Would that be still your position, sir?
If the procedural amendments will lead to a clarification of the intent of the law, then that is perfectly all right.
And do you think that it would be within the premises of the Senate or within the prerogatives of the Senate to allow the situation that we can say that the original purpose of the Senate? Sounds like to me that's almost like going back and saying we're changing the rules in the middle of the game. I've been very careful about that because I don't want these guys to have a leg up on us.
No, that will not really be changing any rules because it's really just putting clarity to how these matters should be handled. But there are really no substantial changes in the rights of the persons to be affected.
Well, we are aware of that. That's why I'm asking the question for the record so that the public and in the future the courts can go back to this discussion and say that we're doing things in a very careful manner not to violate the rights even of prisoners, even prisoners of rights. Is that correct, sir?
It's very correct.
Yes, sir. Very elementary. Now, having said that, we are going to have a technical working group, and it's my hope that the Department of Justice can see our way clear. We have some bills that have been, including mine, including Senator Soto, I think, and others. Maybe we can see our way clear in working Monday, Tuesday, so that we can have a meeting with the committee and report it out to the floor so that no further transgression should be committed. Would you be amenable to that, sir?
Definitely, Mr. Chair. We have seen yesterday copies of the draft bills, and we had a short opportunity to review some of them. And the Department of Justice, Mr. Chair, and honorable members of the Senate of this committee are very gratified that many, if not all, of the suggestions that we made with respect to Republic Act number 10952 have been adequately reflected
Incorporated,
in the proposed bills.
right.
Yes, and we are very happy for that.
And even the fact that you issued an order that 953 that has been incorporated as
Yes,
well.
that we're happy to see that that particular provision that requires prior approval of the Secretary of Justice when in cases of releases
Ito
of
may-
PDLs convicted of heinous
Para
crimes.
maintindihan po tayo, sapagkat ngayon, hindi lang natin nakikinig na lahat at nanonood ng mga tao. Ito lang para mapatunayan na talagang there is a strong effort to make sure that everything is within board, within the law. And that gagawin natin yan, di po ba?
Tama po yun, Mr. Chair.
All right.
Mr. Chairman,
Yes.
just to pursue that same
Yes,
that,
go
that
ahead.
point. We examined the paper trail, yung sa Davao. No? Okay. 25 July 2017, then Officer in Charge Ragas communicated with then Secretary Vitaliano Aguirre. This is Annex J. And everything seems to be in order. Yung case ni Chen Chang Itiz. No. And then subsequently, it was returned to 2 years later. The endorsement was returned to now DG or Undersecretary Paildon, dated April 3, 2019. This time, the endorsement came from Secretary Guevara. Kasi kinlear ito sa Secretary of Justice, then Secretary Aguirre. Inabot ng 2 years, ito yung Annex C. And then, from there, nag-issue na ng memorandum si Yusek Paildon, 8 April 2019, to Superintendent Davao Prison Penal Farm. And that became the basis for Chief Superintendent Postino to issue the corresponding corrections order. Correct, no?
That's correct.
Yeah, okay. So, alam nyo naman pala yung procedure. Kasi laging reference number 1 is Department Order 953. But eventually, you disregarded it. Kasi alam nyo rin, this occurred during the time of Director General Paildon na pinapadala niya pa, or at least endorsement coming from Secretary Guevara back to the new superintendent or the new undersecretary or Bucor Chief Paildon. Nanggaling kasi yon sa communication coming from Ragas to Secretary Aguirre. So nasunod yung procedure, and alam nyo pala yung procedure na yung clause na upon prior approval of the Secretary of Justice. So the case of Chen Chang Tis seems to have followed the procedure, di ba?
You're correct, Your Honor.
Because this was approved by Secretary Aguirre and eventually transmitted back to Bucor by Secretary Guevara. So, ang question is, alam nyo naman pala at sinusunod nyo dati. Bakit all of a sudden, dinisregard nyo na yung approval ng Secretary of Justice in subsequent releases? Just like the June 4 release of the 4 Chinese drug lords, no? And then the August 16 release of Asnar, Balansag, and Canyo. And then the aborted release of Antonio Sanchez. Bakit biglang disregard nyo yung procedure na in the first place, you are practicing before? Legal.
Legal being Attorney Santos of the Bureau of Corrections.
Yes, Your Honor. Nung umpisa, sir, yung 953 na yan, sinusunod talaga yan.
Ayun nga eh.
Ang nangyari po kasi, with the passing of the RA 10575, ang aming alam doon na na-supersede niya yung Department Order 953. Kasi po, ang nakalagay sa Section 8 na sinasabi natin doon na control and supervision ay nasa Bureau of Corrections na. Yung natira na lang po sa DOJ, administrative supervision. Ang problema po kasi, ang dami na lalaya na hindi namin mapalaya dahil sa 953. At sobrang tumatagal po siya, nag-invoke na sila ng arbitrary detention dahil maximum serve na po siya, 40 years. So that's why we decided to pursue the release.
Question. Meron ba kayo maipapakitang dokumento ng rescission order ng 953 coming from the Secretary of Justice?
Wala po.
Oh, wala pala eh. Di binding yun. Di ba? If it has not been rescinded, then it stands. Unless you can show us a subsequent department order amending Department Order 953, then we'll believe you.
Sir, but that what's transpired, sir. That's the real
Secretary Guevara, can we hear your comment? Medyo magulo to.
Since we could not find any subsequent department order expressly revoking or canceling Department Order 953 issued in 2015, then it is our submission that department order subsists
Stands.
and should be followed.
Thank you. Thank you, Mr. Chairman.
Thank you. With the permission of everyone, I'd like to greet and welcome Senator Ronald The Rock De La Rosa. That is spelled D-A-R-A-K. And of course, Senator Francis Tolentino. I already recognize Senator Go. I'd like to beg the indulgence of my fellow senators here. I'd like to call Secretary Mendoza now to make some statements so that we could be enlightened. This is also in aid of legislation part, so that he may enlighten us on his views on the matter. Sir? I'd like to advise everybody that the Solicitor General Mendoza has a hearing deficiency or hearing challenge, but so let's be very patient with him. She has a translator with her, or somebody who is interpreting for her. For him, sorry. Go ahead, sir.
Well, thank you, Mr. Chairman. And
Can
good
you
morning to everybody.
Good morning, sir.
From what I understand, in the hearings are about the time allowance being granted, which has been enhanced. So I will address that issue. I would like to qualify that whatever statements I make are not based on personal knowledge, but are based on decisions rendered relevant to this case. And I have drawn those decisions as reported in the SCRA. Now, the basic provision of the Revised Penal Code is Article 97, Allowance for Good Conduct. The good conduct of any prisoner in any penal institution shall entitle him to the following deductions from the period of his sentence. What I would like to emphasize is that is the word sentence, from the period of his sentence. As a matter of fact, under Article 94, among the grounds for the extinction of criminal liability is good conduct allowance, which the culprit may earn while he is serving again his sentence. So the critical point in on this matter is what is the sentence of the prisoner. I think there has been a lot of confusion on this. If you will take the often mentioned Sanchez case, or the Peñalosa case, or the Cebu case, then you have decisions of the Supreme Court. The decisions are clear as to what penalties have been imposed. 7 reclusion perpetuas in the case of Sanchez, plus 2 in the Peñalosa case. And in the Cebu case, similarly, reclusion perpetua. But from what I hear in the discussions, too often this seems to have been disregarded, and there is mention even of the maximum being 40 years. I think that is basically erroneous. The penalty or the sentence that these prisoners must serve are those which are in the decisions of the Supreme Court. That means in the Sanchez case, 7 reclusion perpetuas, in addition 2 in the Peñalosa case, and similarly in the Cebu case. Those have not been changed. There is reference to Article 70 because of the provision that, and I read the so-called threefold rule, notwithstanding the provisions of the rule next preceding the maximum duration of the convict's sentence. I want to emphasize the word sentence shall not be more than threefold the length of time corresponding to the most severe of the penalties. Such maximum period shall in no case exceed 40 years. What I want to emphasize is that this provision applies to this sentence, to no other. So if one is to apply, look at this, one must look at the sentence. In the Sanchez case, you must look at the sentence which imposed the penalty of 7 reclusion perpetua in addition 2 reclusion perpetua in the Peñalosa case. So if you have any good time allowance, you must deduct that from these penalties. These penalties have not been changed at all. Once a decision is rendered, it is immutable, final, and executory. The threefold rule, the so-called threefold rule, the 40-year rule, in order that it will apply, it must have been invoked by the accused, and the accused should have asked the court in rendering the judgment to amend the decision to reflect this fact. But there was no such effort even, so the decision of the Supreme Court remains the same. So that in the Sanchez case, if you are going to talk of good time allowance, then you must reckon the good time allowance from the 7 or rather 9 reclusion perpetuas, not from 40 years, but from another year. Sanchez was claiming a release because of good conduct allowance and then a maximum of 40 years. I think, as I said, what has been overlooked is that the sentence as rendered and confirmed by the Supreme Court has not been changed. So that is the sentence that must be served. If any good time allowance is to be applied, that good time allowance must be deducted from that sentence. And there is no maximum of 40 years. The question may ask, how about this? Well, that is the problem of the lawyers. They should have asked the court to amend the decision. But I think they were in a bind because Sanchez continued to deny that he was guilty. So that invoking this would have been inconsistent with his contention that he was not guilty. So, being guilty, he could not invoke the threefold rule. Because if you invoke the threefold rule, then you assume that you are guilty of the offenses that we just determined, which is the most serious of them. So that I think many of the discussions that have been made are actually irrelevant because they are based on an erroneous judgment or sentence. What I want to emphasize is that in all of these provisions, they refer, and I emphasize and I quote, to the sentence, to no other. So you must always look at the sentence before you consider any good time allowance. Because, for example, in the Sanchez case, I hear he was claiming because he had good time allowance and then you add it, so it amounts to 40 years. But that does not apply because he did not raise that point. He did not ask that the threefold rule, if you apply the threefold rule to his judgment, it would have been 3 times reclusion perpetua or 3 times 30 or 90 years. Then you can ask for 40 years. But the judgment of the Supreme Court, it is well established. Once rendered, it is not in any way subject to change. It is immutable. It must be implemented and executed as rendered by the court. Incidentally, I might add, if the Congress should enact a law which grants excessive time allowance, which undercuts the judgments of court, that might be subject to a constitutional question because of our basic principle of separation of powers. The legislature cannot undercut the jurisdiction of the judiciary in rendering a judgment. It cannot render inutile a judgment of a court. Read, for example, the decisions in the court, particularly in the Cebu case. The proceedings really were terminated because of the will and stamina and strength of the trial judge, notwithstanding the efforts of the counsel to delay and suspend the proceedings. So this cannot be simply swept away by legislation. It is going to be in violation of the separation of powers, which is a basic principle of our constitutional democracy. That is what I want to emphasize, Your Honor. Well, incidentally, I may add, I had a little experience during the time of Secretary Vicente Abad Santos. I was a member of the Board of Pardons and Parole. I went to Muntinlupa with the carpetas, interviewed personally the prisoners before we decide whether he would be entitled to parole. You must remember, we have what is called the indeterminate sentence law. Because of the indeterminate sentence law, there is a minimum and a maximum of the penalties. Once you attain the minimum, then you're entitled to parole. We took great care that only those who have served the minimum are allowed to be released. But that is now been swept under by this enhanced good conduct law. So that is what I want to emphasize. Incidentally, maybe, although this is not subject of this hearing, I would like to draw attention to the fact that the prisoners are not only in the National Penitentiary. There are thousands and thousands of prisoners in the jails all over the country. And what is striking about this is that more than 90% of these prisoners have not been convicted of any offense. That is why I call them innocents in jail. Since they are presumed innocent, you have them in jail, and they represent thousands and thousands of them. As I said, more than 90% of those detained have not been convicted. So, I think, but theoretically, that is the responsibility of the Supreme Court. Because since I have not been convicted, it is the responsibility of the Supreme Court to assure that they are tried expeditiously. Well, anyway, thank you very much, Mr. Chairman, and the members of the committee.
I agree with you, Mr. Secretary. Thank you very much, sir. That enlightens us, especially the last part where there are thousands, as you say, of people under detention, and that the courts must act expeditiously on these cases. But if I understand you correctly, the reckoning point is the sentence. And some of the points you discussed, para maintindihan sa Tagalog, kailangan muna bago mabot doon yung minimum sentence para mag-qualify sila sa GCTA. And there's a basic provision po sa mga nakikinig at nanonood at yung mga kasama natin dito na hindi po dapat pumasok yung paghimasok ng legislation o ng Kongreso dun sa mga ginagawang pagsentensya ng mga preso. So, dapat po pag-ingatan rin yan sa pagbalabas ng batas. At saka yung sinasabi nyo kanina dito tungkol dun sa indeterminate sentence to. Yun na, sinabi ko na po yung minimum dapat ay masinbihan muna bago sila qualify. Kaya sinasabi nyo, in the case of Sanchez, na siya ay convicted na 3 times 40 ho ba yun? Or 40 or 30? Ang multiplication po natin dyan, kung 120 years old. Pero triple pa nga, no? Pero ito 9 times 9 times ang conviction niya. 3 times 90 is about 270 years. Malayo-malayo ay nakompitin nyo talagang hindi qualified. Tama po ba yung understanding po namin?
Ang penalty niya, Sanchez, siyam na reklusyon perpetua. Bawat reklusyon perpetua sa batas natin, binibilang na 30 taon.
30 years, opo, 30 years.
9 times 30. Tama ba mathematics ko? 9 times 30, 270. Yan ang hatol sa kanya. Hindi yan nababago. Hindi nyo pwedeng baguhin yan sa good time allowance law. Ngayon, kung gusto sanang mabago ng abogado, humingi sana ng motion sa husgado. Pero hindi ginalaw yan. Hanggang ngayon, ganun ang hatol ng husgado. Yan ang sentensya. Any effort must be based on the sentence.
At dahil may problema ho sila, dahil hindi lang magawa yun, dahil ayaw aminin na sila ay guilty. Hindi po ba? Kaya meron silang quandary. Hindi lang maamin na guilty sila, kaya hindi nila ma-question. Catch 22 ang tawag ko. So, kung we thank you. Secretary Ibarra, do you have a comment on the matter? By the way, I must warn you, he was my professor in UP, no? So, I had the privilege of being under Secretary Titong Mendoza, and he even encouraged me when I was running. He probably thought I would be a better politician. He did not bar me from running for the Constitutional Convention. And he was one of the few who encouraged me to go ahead and run. I don't know if he remembers, but that was the story. Go ahead.
The point of the Honorable former Secretary of Justice and Solicitor General is very well taken. Of course, we perfectly understand what he was referring to when he says that any GCTA should be based on the actual sentence imposed by the court. But more importantly, and I think what is more relevant to Congress is his last statement about the court's judgments being supposed to be immutable, cannot be changed, but subsequent legislation may somehow, in effect, alter any final judgments already rendered by the court. This we saw in the case of the imposition of the death penalty. So the case of Leo Echegaray, right, who was admitted the death penalty, right, and subsequently, of course, there were other people, I suppose, other convicts who were sentenced to death by virtue of the death penalty law. All right, so that was the sentence imposed upon them. But subsequently, in 2006, there was a law passed by Congress which prohibited the imposition of the death penalty and for those who were sentenced to death, their sentence was commuted to life imprisonment. So that, well, I'm just pointing that out. So if this is a point for the Congress to consider, then so be it.
Of course, the other point, sir, is that is practically reducing the sentence, but upon the other hand, there is also a provision, I think, if I remember, memory serves correct, that na-commute na yung sentence nila from death to life, hindi na sila qualified to have their sentences reduced.
Yes.
Is that your point? Is that your, are we in agreement on that?
All right, okay.
Thank you very much. I like you. You always agree with me. Thank you very much. Are there any questions? We're privileged to have Secretary Mendoza. He has been very, this is the kind of citizenry that we need. All throughout, he has been watching the proceedings. At nagtitext po si Secretary Mendoza at sinasabi niya yung sinasabi niya ngayon. Kaya mabuti lang ho at kusang loob na pumunta dito, ang tawag ko dyan, palagi ulit, kusang loob, malasakit at kapwa-tao. Pero nyo yung sinabi niya, may kusang loob siyang ayusin yung pag-aaral natin dito, nagmamalasakit siya, hindi naman siya binabayan ang pupunta dito, at makatao sapagkat sinasabi niya, 90,000 people, 90% ni 90,000 na mga nakukulong ay lumalampas sa maximum na dapat isentensya sa kanila at dapat magkaroon ng heads up dito ang Korte Suprema. Pagkat nasa Korte Suprema lahat ang may hawak ng pag-dilitis. Kaya nga ho, ang Committee on Justice at yung Senadong ito, pinasa nga ho para mabawasan yan. Yung halimbawa yung arresto mayor, arresto menor, pinasuo namin yan para pwede na silang magkaroon ng service to the public, para mabawasan yung mga nakakulong. At naghahanap pa ho tayo ng paraan para mas lalong mabawasan yan, para pinakamabilis ho niya siguro, Mr. Secretary Mendoza, is kung tayo ay naka-computerize, talagang malinaw na makikita na yung mga bata, lalo na yung mga bata na dapat nakahiwalay sa preso, sa detention, o yung mga tao na under detention, kung kailan sila pumasok, mabibilang natin kagad malaking tulong na mapapalabas sila habang hindi natatapos yung kanilang pagdilitis. Thank you very much, po. Sir. Yes, go ahead, Senator Maxon.
I just need to be clarified. Parang statement ni Secretary Guevara, yung immutability of the court, meaning the Supreme Court ruling, is not really absolute. Tama po ba? Interpretation ko. Because in the case of the abolition of the death penalty, by legislation, we altered the decision of the Supreme Court. So, hindi po absolute. And what you're telling us is that's something that we have to ponder when we craft our legislation, kung we will abide by the interpretation of the Honorable Secretary, former Secretary Estelito Mendoza, or consider your opinion. Tama po ba yung interpretation ko? I just need to be clarified because we're now on our way to crafting legislation along this line.
Mr. Senator, the doctrine of immutability of final judgments is a very general rule. All right, and in most cases, this has been invoked in civil cases. All right, so in any event...
In civil cases?
Yeah, I have seen this doctrine applied mostly in civil cases. So, of course, we also have this principle that whenever a penal law is passed, which will be beneficial to somebody who has already been sentenced and is actually serving his sentence, that the benefit of that penal law, which is just being applied, or rather enacted, will retroact to him. So, in a way, come to think of it, that's also somehow affecting or modifying judgments rendered with finality by the court. So,
well, from the point of view of legislators like us, while the opinion of the former secretary is very valuable, it is your opinion that matters as of now, because you're the Secretary of Justice. Thank you very much, Mr. Chairman.
All right. We thank the Secretary, former Secretary of Justice, my esteemed professor and my fraternity brother. And yan yung makikita yung kumisa may mga loko-loko rin sa fraternity na napaparusahan, pero marami rin magagaling na ginagawa ang mga fraternity. And so I just want to say that we thank the Secretary Mendoza once again. Are there any more questions? Are there any questions? The Honorable Christopher Christ-Bearer Bongo. Wala na. Senator Tolentino is also here. I just want to make that point across. Meantime, I will ask Senator Soto to take charge, or Senator Lacson to take charge, because the chairman has liquidity problems right now. Thank you.
Thank you, Mr. Chair. Mr. Chair, wala bang limit ito? Wala. Thank you. Wala, iniwan niyo naman ako.
I'm the one.
As I have said,
I'm the one presiding, so walang limit.
Thank you. Sana si Bato. As I have said, heads will roll, and now the President has spoken. I fully support the call for the immediate arrest of all recidivists, habitual delinquents, escapees, prisoners convicted of heinous crimes who were released because of the wrongful application of the good conduct time allowances under Republic Act number 10592. I just have a few questions to the DOJ. May we know who have surrendered? Maybe, kung bawal pong sabihin in public, maybe you can tell me later po. May nag-resist na ba? Nagkaroon na ba ng shootout since they are already fugitives from justice? And I am urging my colleague, Senator Bato, nawala, saan si Senator Bato? The former Bucor chief, to help in the recall. If not, maybe he can implement the shoot-to-kill order if they resist arrest. Babalik pa ba si Bato? Anyway, you may answer, Secretary. Diba?
Mr. Senator, we have received information that several PDLs who have been prematurely released on account of GCTA have sent feelers for their voluntary commitment or recommitment to prison. So probably they're just waiting for the mechanics or the procedure on how to go about doing this. But we're gratified by the knowledge that these people understand where we are right now, why the President is doing this. And we hope that many more will follow after, within the next 15 days, so that we don't have to do some coercive measure. The 15-day period granted by the President is a period of grace, wherein they can voluntarily turn in themselves without any coercive action being taken by the government. So as I stated earlier, all they need to do is go to the nearest police station or military facility and state that they are one of the 1,900 PDLs who were previously released on account of good conduct time allowance, and that they have been convicted of what may be considered a heinous crime. All of these details will be taken down by the police unit or the military unit where they will turn themselves in. And these police units or military facilities will in turn relay the information to the Bureau of Corrections, who will then take the necessary action for the recovery of the person of these PDLs who have turned themselves in.
Thank you, Secretary Guevara.
But we are not aware of any violent incident as yet, Senator Bong.
Nasanay ka na kay Senator Gordon, sir. But we don't have to stop there. There are still allegations of GCTA for sale. Mayroon pa ring mga special treatment sa loob ng bilangguan. Ma'am, balita ko po nung nasa litrato po kanina, habang naglalakad daw po si Sanchez ay sinundo raw siya ng pedicab. So, mari bang paki-explain po nito? Mayroon pa rin mga talagang paulit-ulit naming naririnig na may mga special treatment po sa loob. Maraming nagpapapasok ng mga contraband, marami pong nahuli. This is what happens. This is the reality. We have to get to the bottom of this para matuldukan na po. Sawang-sawa na po ang Pilipino sa nababalitaan nila. To the DOJ, do your sworn duties. I am sure you are very competent, sir. Let us fix our correction facilities. All prisoners, mayaman o mahirap, must be treated equally. Pare-parehas lang po. Dapat ang lahat. Walang palakasan sa bilangguan. To my fellow senators, we have to do our part for the people. Let us heed the call of the nation. We need to amend the law immediately to make it clear that recidivists, habitual delinquents, escapees, and those convicted of heinous crimes cannot be granted time allowance. let us force the Bucor to be transparent in the releases of any prisoner. This is our solemn duty to promote the general welfare of our people and protect them from threats. It is our mandate to craft laws that will secure justice. Yan lang po. Salamat po, Mr. Chair, sa oras na unlimited. Binabalik ko na po sa iyo ang... Thank you, Mr. Chair.
Hindi naman immutable yung decision natin. Okay, Senator Rivera? I think, I just have to ask this now. Kasi, alam nyo, pagka nag-hearing tayo, marami sumasagot. It may be pertinent. Yung bang si, well, kulang-kulang information. I'll just ask Secretary, because somebody's asking about justice for his murdered son na yung nandun sa Muntinlupa ay nabibigyan raw ng special privileges na baka isama raw dito. In fact, I also have a text yesterday. People thanking us, thanking the President, Senator Go, thanking the President because natakot sila na baka makalabas. Ganito kalakas ang hampas nitong kaso nito na hindi makalabas yung mga taong pumatay at mabuti na linawan rin natin kay Secretary Mendoza na talagang hindi papasa si Mr. Sanchez dito sa sinabi niya. Pero nakabuti talaga yung naka-aksyon kagad ng Pangulo sa advisory ni Secretary Guevara at ni Secretary Senator Go na talagang ibalik lahat sa preso yung mga nakakulong. And it's my hope na ulitin ko lang yung sinabi ko, dapat magawa kagad ng paraan, mahuli nyo lahat yan, lalo na sa inyo, yung mga pinalabas na doon ng mga, sa inyo yung drugs, no? Yung Chinese, Mr. Faustino?
That's correct.
Okay, kailangan, andun pa naman sa kwa, di ba? Nasa BI.
Nasa BID Davao po as of yesterday.
So pwede lang balik kagad yun, di ba?
You're correct.
O tumitingin ka kay Secretary Guevara. Ngayon tumitingin kay Secretary Guevara, nung araw hindi kayo tumitingin sa kanya. Palabas lang kayo ng palabas. Nakikita namin lahat yung ginagawa nyo dito. Anyway, we have, yes, Mr. Manuel, is it Manuel Luna? Yeah.
Good morning. Good afternoon, Senator. With your permission,
Are you asking me to serve lunch already?
no, Your Honor.
Thank you.
With your permission and the permission of the committee, on behalf of the President's Anti-Corruption Commission under the Office of the President, we'd like to inform the committee that we are conducting a parallel investigation of this controversy. And we have a specific mandate to finish the investigation as soon as possible. And if, with the indulgence of the committee and the Honorable Chairman, may I respectfully request, on behalf of the en banc of the Commission, for a copy of the transcript which will facilitate the early or expeditious resolution of this investigation of the Commission, so that we can submit to higher authority our recommendations. I'm talking of the President, Your Honor. We are bound to submit our recommendations to the President as soon as possible on this controversy, Your Honor.
Let me assure you and the public that the transcribed notes of these proceedings, as well as many other information about the Senate, is available in the website. I'm very, very pleased about that because last night we looked at it. Ang bilis ng mga stenographers natin. I give them a very, very silent, loud applause in my heart. If there is such a thing. Because talagang masipag sila at nagagawa naman. So you can get it there.
Salamat po.
You can get it there. Yes? I think we'll call a recess so you can all have lunch because we're waiting for a very vital witness. With your permission, I'd like to call a recess so that as lunch is being served, I think I'm very quick on the hint by Mr. Luna that it is already good afternoon. So you see right away, dumating kagad yung pagkain ninyo. No? So we will have we will suspend it for a few minutes. Session is suspended.
Uh,
Yes.
Mr. Chair, may I request be excused because I have to attend the DOJ budget hearing at 1:30 at the House of Representatives.
Don't worry, it will go to the Senate. If they reduce it, we will increase it here.
Thank you, sir.
Hindi sa kailangan. Baka kailangan namin kayo pagka dumating ho yung witness eh. Ay, Undersecretary, yan naman nga pala, si Undersecretary Marco. Undersecretary Marco and Undersecretary. Oh, para natapusin ko naman na para ba. Anyway, kung aalis kayo, dyan naman sila.